Australian Information Commissioner, thanks very much for coming and talking to us today. Committee's received your submission as number 24. Professor McMillan, do you wish to make any amendments or alterations to your submission?
No alterations. Thank you, Chair.
For the Hansard record, would you please state your full name and the capacity in which you appear today?
Right. John McMillan, Australian Information Commissioner.
So the Senate has resolved that an officer of a Department of the Commonwealth or of a state should not be asked to give opinions on matters of policy and should be given reasonable opportunity to refer questions asked to the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy. It does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Officers are also reminded that any claim that it would be contrary to the public interest to answer a question must be made by a minister and should be accompanied by a statement setting out the basis for the claim. Professor, do you wish to make a brief opening statement?
Yes, I will, Chair. Thank you to the committee for the opportunity to speak to the submission from the Office of the Australian Information Commissioner. In my opening statement, I'll address the issue of privacy protection, which is one of the three areas of responsibility of the Office. It's heartening to see that there is strong recognition in many of the documents before the committee that privacy protection is one of the twin purposes of the Telecommunications Act. This is stated, for example, in the report of the Parliamentary Joint Committee on Intelligence and Security, in the submission of the Attorney-General's Department and in submissions from many of the other participants in this inquiry. However, anybody doing an initial or surface reading of the TIA Act is unlikely to be aware that privacy protection is a central theme of the Act. It's not mentioned in the long title of the Act. There's no objects clause in the Act. The word privacy is mentioned in only 5 sections of a 300-page Act and usually as one item of a list to be considered before a telecommunications interception warrant is issued. There's nothing in the TIA Act that links it to the body of national privacy law or principles that is now more than 25 years old, and that on a recent community survey by my office is known to 82% of the population. My own office, which is the National Privacy Regulator, does not have any direct role in relation to the administration of the TIA Act. Whether privacy protection figures strongly in the administration of the TIA Act is not readily ascertainable from the public record. The Attorney-General's Department has made the point in its submission that there is no requirement for any public report on whether judicial officers and tribunal members who have approved the issue of warrants have specifically turned their mind to this issue and, for example, required additional information about privacy impacts before a warrant is issued. The Ombudsman's Office has made the point in its submission that while it has a role in scrutinising the records maintained about warrants, the Ombudsman reports those findings to the Attorney-General's Department and not directly to the Parliament or the public. And may I here add a reflection from my own earlier term as Commonwealth Ombudsman from 2003 to 2010, that the Office did focus in its inspections on whether warrant information adequately addressed the issue of privacy protection. We were at times strongly critical of warrant applications that merely ticked the box relating to privacy consideration without giving a proper explanation of how that issue was considered. But at the time we also got some pushback on the basis that we were overstepping our role as it was for a judge or tribunal member to be satisfied about that issue. About whether the criteria in the Act were met. I add that I have no recent experience on this issue. The practice may be different, and if so, hopefully it is different uniformly in Australia in respect of the thousands of warrants that are issued each year. I'll finish with one other observation. If privacy protection is to be given a more dedicated focus in the structure of the TIA Act, as I think it should, then deeper analysis will be required. For example, support is expressed in a number of the submissions to this committee for the Parliamentary Joint Committee's recommendation number 1 that a privacy objects clause within the TIA should accord with the privacy principles in the Privacy Act. That's a laudable sentiment, but what does it mean? There are now 13 Australian privacy principles that cover issues such as publication of a privacy policy, notifying people when personal information is collected, distinguishing solicited from unsolicited collection of personal information, distinguishing primary from secondary uses of personal information, allowing individual access to and correction of personal information, and regulating the cross-border data flow of personal information. So which of those principles readily applies to the TIA Act and how? Equally, the Privacy Act, as amended from March this year, contains an important distinction between sensitive personal information and other personal information. Will that be built into a TIA regime? The privacy principles also sit within a regulatory framework that enables the OAIC to undertake complaint investigation, own motion investigations, performance monitoring and auditing, code development and negotiation of voluntary privacy compliance undertakings. Now, are any of those features of that regulatory framework applicable to the TIA? And if so, how would they apply and who would the regulator be? So thank you, Chair, for the opportunity to make those introductory remarks. May I just say I'm having some having some fairly severe hearing problems at the moment. So if I can just ask if you're able to speak directly into the microphone, or otherwise I may have difficulty picking up the question. No, thank you.
Indeed, thank you, and thanks for letting us know. Senator Seselja, do you want to kick off?
Yeah, thank you, Chair. Thank you, Professor McMillan, for being here. Can you, in your submission, you highlight the risk of regulatory fragmentation, and I wonder if, for the committee's benefit, if you could explain what risks regulatory fragmentation poses and how this might be addressed in amendments to the TIA Act.
I suppose the regulatory fragmentation comes in many ways at the moment. For example, as the committee would be aware, some warrant some of the laws in this area apply to collection by Commonwealth, state and territory authorities. Some only telecommunications interception applies only to Commonwealth. There's a distinction there between the members, the organisations part of the Australian intelligence community and other organisations. And then there are some national regulators like myself that have no direct role in this area. There are also suggestions in submissions that thought should be given, for example, to creating a new regulator for TIA purposes, a public interest monitor or something of that kind. I have no map in mind of what the regulatory framework should be, and I don't make an ambit claim that the OAIC is necessarily the better body to be playing the privacy oversight role. I think we should have a role, even if it is only on an advisory, collaborative basis with other agencies. At the end of the day, realistically, it's likely that government would prefer a division between, the role of the Inspector General of Intelligence and Security in relation to the intelligence community and the role of the Ombudsman in relation to other agencies, and I don't have any problem with that. One difficulty with that arrangement, of course, is that the Privacy Act does not apply in the intelligence community, and there are special reasons, but could, for example, the Privacy Act apply to the intelligence community in relation to activity under the TIA Act, or at least if There is a privacy code developed, a set of privacy rules that draw from the Privacy Act and other sources. Should that apply uniformly to all activity under the Act and be applied in a consistent manner by all regulators, and their work then brought together in a consolidated form.
You mentioned the public interest monitor as one suggestion. Do you have a view on whether that's a good idea?
I'm in favour. At the moment, there are quite a number of regulators, and so I'm not in favour, obviously, of unnecessary duplication and fragmentation in that area. But again, each of the the way I always, I suppose, to come at these things is to ask what new oversight, regulatory, auditing, monitoring, supervisory function, inspection function should be performed. Can it sit within one of the existing regulators? If not, what new kind of regulatory body called public interest monitor or whatever could take on that role? So I think if it's approached in that way, one is likely to come up with the answer that there is no need for a new body. But generally, the calls for creation of public interest monitors reflect a degree of concern, anxiety, exasperation about failure to address gaps in the present oversight framework.
Just on that, in terms of gaps, I mean, do you see an issue in terms of, is this a process issue at the moment, or is this an issue around outcomes? Have you seen evidence that would cause concern in terms of, warrants being issued where they shouldn't be, or interceptions happening where they shouldn't, or is it, from your perspective, a process issue that you want to see us get right?
No, I have no opinion on whether warrants have been issued when they should not have been issued. That's essentially, in many instances, a process that's subject to independent scrutiny by a judge, a tribunal member, sometimes not. But I do have some concern about the oversight arrangements in two ways. One, the Act currently contains bare detail on, for example, how privacy is to be addressed, what is meant by considering the impact of privacy, and I can come back and comment on that in a moment. And it equally contains similarly inadequate detail then on what records will be maintained. As I said, during my period as Ombudsman, it all may have changed. There was also a lively debate about whether it was purely within the jurisdiction of the judge or tribunal member to decide whether the criteria were met, or whether it was appropriate for an independent scrutiny or regulator to have a look at that. I obviously pushed the view strongly that it was appropriate for the Ombudsman to do that. But I checked to the extent that I could on the public record before coming along here, and I was unable to tell, from my own, unstructured but probably well-informed search about what information is available out there. I had difficulty in answering all the questions that I'm just raising.
Just on a final point on another issue, the issue of mandatory data retention has received a lot of, has been a big focus in terms of a lot of the submissions, and I'm wondering whether you have a view on mandatory data retention. Is that something you support, and if so, what do you see as some of the issues with mandatory data retention, or indeed if not?
Just two comments. One, most submissions acknowledge that data capture involves data retention. Now, data retention is standard. On the other hand, authority as high as the US President now agrees that too much data was collected on a random and indiscriminate basis as part of an interception program there. So, in between, there lies an area that will be contested, but where answers will be found. And I suppose my other observation is that the term data retention, in fact, camouflages a whole range of other issues. There's the question of data, data capture and data minimisation and data security and data storage and data use and then at the end of that process you get really to the issue of retention, and then it becomes a question of retention for how long. My anecdotal observation of the debate is that all of those issues are sort of tossed around fairly indiscriminately and all under the umbrella of data retention. And so at the end of the day, as that suggests, what we clearly need is to untangle those issues and work through them on a systematic and principled basis about who can collect data, when, for how long it will be retained, and the rules may vary, so many years for this, so many years for that.
Okay. Senator Marshall? No. You all right? Senator Xenophon?
Professor McMillan, can I just go to whether you have any opinions in relation to the announcement made by the US Attorney General Eric Holder in July last year, where he issued some quite comprehensive guidelines in terms of surveillance of media organisations and set out certain criteria and the like, which circumscribe the power of the Justice Department to tap the phones or to undertake metadata searches of media organisations, and it included having a process of consultation with media organisations in order to avoid the sort of the mass surveillance that Associated Press, for instance, was subject to. Firstly, are you familiar with Mr Holder's guidelines from July of last year? Is that something that you've had a chance to look at in the last few months?
No, Senator, I'm aware of them, but I haven't looked at them. And the reason is that my office the OIC has no direct role in this area, and so we've kept abreast of developments, but not examined them or formed any professional opinion on them.
Do you, and I'm happy for you to take this on notice, do you think there would be any benefit in having the sorts of guidelines, and I'm not, asking you to comment on the content of the US Attorney General's guidelines, but to have a framework where, for instance, media organisations know the circumstances in which they may be subject to metadata or telephone interception surveillance, particularly from my point of view, where they are dealing with whistleblowers in the context of Section 70 and 79 of the Crimes Act, and for that matter, members of Parliament as well. In terms of the surveillance of an MP who sees a constituent, whether they're a public official or not, who has something to say about maladministration, for instance, within government.
Yes. Yes, I'm a strong supporter of an approach of that kind, and indeed the Privacy Act is really built around a few key principles, among which are having a principled base approach, often called guidelines, but in reality they're legal rules. And the other, another important theme that underlines it obviously is the one of transparency, that when there is transparency about what information is collected by whom, to what uses it can be put, and for how it will be stored, for how long, how it will be shared, then it enhances accountability, but it also gives individuals greater control of their of the way they use and share personal information, including their use of telecommunications devices.
And so guidelines or legally binding principles in respect to surveillance you think would be a useful reform?
Well, I think underpinning the guidelines should be some essential principles in the legislation, and there's been a proposal not yet implemented for an objects clause in the TIA Act that spells out that identifies privacy and perhaps proportionality as important principles, and then I think guidelines can build on provisions of that kind. Equally, as I'd said, the TIA Act uses the word privacy a few times without really defining what is meant. Now, there's scope for spelling out with legislative criteria. When somebody is considering a privacy impact, they should consider what communication is being intercepted, what information is captured, whether less intrusive means were considered, whether sensitive information is captured in that. And again, then guidelines can address each of those criteria in greater depth.
And finally, in the context of my particular interest in this field relates to public servants, members of the public coming forward to MPs who, with information that could be characterised broadly as whistleblower type activities, and I'm particularly concerned about the case of Alan Kessing, which for whom I've advocated for in the past and will continue to do so in the future. Do you think that in terms of any guidelines or protections, there should be a greater level of protection in respect of the surveillance, either metadata or telephone interception, for in Section 70 and 79 cases of the Crimes Act, where it involves either journalists or and particularly members of Parliament that constituents with concerns go to, because I found it quite chilling when Federal Police Commissioner Negus confirmed that there were a number of members of Parliament that were the subject of surveillance in the context of Section 70 and 79 on answer to some questions I put to him in Senate estimates, that there are, I think, up to 5, or I think that means there could be up to 4 members of Parliament that or 4 members that have been subject to this sort of surveillance in the context of Section 70 and 79. Do you have any views about?
No, I don't, Senator. I have noted, for example, in the Attorney General's submission, a discussion about the difference between content and non-content data, or metadata and content data, and that submission supports the need really to distinguish the privacy and other issues relating to different kinds of data, but I don't have any opinion at this stage what those rules should be. Point made many times that it would probably be helpful if there were some, some template or draft, an exposure draft guidelines or amendments there for this analysis.
Look, only insofar as this relates to your duties as Information Commissioner, I wonder whether you would care to comment on notice on the findings of the expert panel that President Obama set up in respect of mass surveillance. I think that President Obama's the inquiry of his expert panel found that the expert panel appointed by President Obama could find no evidence at all that mass surveillance had prevented any terror attack, and whether...
Yes. Could I just take that on notice? And I'm happy to, quite happy to go away and consider whether there's any comment we can usefully make.
Yes, thank you. Thank you, Chair.
That's great. Thanks, Senator Xenophon. I might continue on in that line. What's your view of the degree to which Australian citizens' private data might have been compromised by those same programs, given that...
Sorry?
I beg your pardon, you did advise us at the outset.
Yes.
That Australians' private data might have been compromised by those same processes that our United States colleagues are now grappling with.
Yes, no, I have no view or opinion on that, Senator.
Okay. But is that not something that would have crossed your desk in your various roles of protecting people's privacy and protecting the integrity of information in this country?
No, to the best of my knowledge, it's not crossed our desks just because of the areas that are excluded from the operation of the Privacy Act, and in particular the intelligence community.
Okay, so you'd be formally precluded from actually going there?
Yes, that's correct. Yes.
Thank you. That's useful to know. Backtracking briefly to the comments that you made a moment ago on metadata. So the Attorney General's Department has provided the committee with their working interpretation of what they mean by metadata, and we can provide that for you if that'd be useful. And they break it into two categories of data that relates to the persons and data that related to the network or the traffic that allowed that communication to occur. And it seems to me that we're dealing with actually a very broad spectrum of material, from virtually innocuous to extremely invasive and very intimate social network mapping and location, real-time location data and so on, which is entirely outside the system of warranted intercepts that we have established in Australia. Do you think there is any room to move any of that more intrusive end of the metadata spectrum into the warranted parts of the Act?
I'd have to take that on notice, Senator. It's not something that I've turned my mind to. As I indicated earlier, though, I think one option for consideration is whether the privacy principles that apply in this area, whether in a TIA Act or elsewhere, should apply uniformly in all areas, including areas that are currently excluded. If privacy is to be given, I'm here only talking about the privacy dimension, but if it is to be given the prominence that submissions and reports seem to indicate, then I suppose it at least casts the onus to others as to if privacy is one of the twin themes of this legislation, it's for others then to justify why there would be an exception.
That's useful, I think. Conclusion to draw. So if we could maybe ask you, if you're offering to take that on notice and give that some further consideration, the fact that in Australia and in like-minded jurisdictions, there are very serious procedural hurdles around tapping a phone or reading an email.
Yes.
And then a very, very large step down to purely administrative processes for mapping your precise location everywhere you go.
Yes.
And I have a very severe problem with that. It's one of the things that committee's dealing with. Why such a different level of oversight, including judicial oversight of email and phone calls, and these new categories of data that came along after the Act was drawn, that simply didn't exist, that the framers of the TIA Act couldn't have contemplated, that we'd all be carrying around portable tracking devices.
Yes.
The Act is practically silent. We have a warranted regime which is quite robust. We have a warrantless regime which is...
Yes. One explanation is given is that the law just hasn't caught up with technology, and the other explanation is that there's some resistance to allowing an extension to the regime. Yes.
There are reasons why it hasn't caught up yet.
Yes.
But that's part of the work that we're doing now. You note that fragmentation increases the risk of inconsistencies arising in the level of privacy protection. So a wide variety of agencies operating in some cases under different acts. Your submission talks about how that fragmentation might mean uneven interpretations or uneven privacy protection.
Yes.
So I've got two questions. One is how you think that fragmentation should be reduced. And the other is, do you see any ways in which fragmentation actually provides a measure of protection, inadvertently enough, in that these data sets aren't meshed together, that material's not being shared, that in fact that fragmentation might even afford a measure of privacy protection?
Yes, that's an aspect I hadn't considered, but agree that could be the case. Sometimes the fragmentation in terms of multiple regulatory bodies is essential because of the particular expertise within the regulatory body, and certainly if that is the explanation for fragmentation, then it overall strengthens. But the other dimension you suggest is one I've not considered, but it's an interesting possibility.
Because you go into that at some length. So I'm just wondering whether you have specific proposals for reducing regulatory fragmentation, at least.
No. I think it would be the place to start. Really, is in a sense to draw a map of what's there now. The map to some extent is in the minds of all of us who participated in this inquiry, but there's no place to which you can go to find a description of what kind of oversight exists and for what purpose, and how it interacts with other parts in the system.
Yeah. Do you have any visibility of jurisdictions overseas that are grappling with exactly the same problems? Overseas that are grappling with the same problems?
No. The Privacy Act, for example, is it has an extraterritorial operation, but only in relation to entities that have an Australian link. Now, increasingly in an Australian in a global and technologically driven context. Bodies that do have their headquarters and operating centres overseas can have an Australian link. Companies that have a meagre presence in Australia can nevertheless be carrying on business in Australia because Australia is part of the targeted commercial area and their representatives, and so the Privacy Act will apply. But it can be quite difficult at times. Particularly, for example, when we get complaints about large multinational social media organisations, to decide whether it does have an Australian link, and in particular whether the activity under investigation is an activity occurring within Australia for Privacy Act purposes.
That's difficult. You've proposed that we consider following objectives in our review. Reduction of fragmentation was one, proportionality was one, community expectations was another. How do you propose that we judge community expectations? Senator Marshall put up a few questions before about, look, has the concept of privacy been annihilated? Do people not expect this anymore? Should we adjust our expectations?
No, when I looked again at our submission, I thought community expectations doesn't sit on the same plane as the other matters mentioned in the submission. I think community expectations is probably better regarded as just a conclusion to the submission, drawing attention to how this is important.
Okay.
I think it's interesting, as I mentioned in my opening submission, that over 80% of Australians know of the Privacy Act. So if you're talking about a regime like telecommunications interception where privacy is one of the twin themes, I think it is correct to ask, well, how is it linked to, aligned with, how does it compare to the Privacy Act? That's how people understand privacy. Privacy Act, privacy regulator.
Yep. No, that's useful. And yeah, just to correct the Hansard record, at no time did Senator Marshall use the word annihilated.
I was going to say you put the whole thing much more elegantly than I did.
But you had tempered your views more than I'm prone to. What about proportionality? At what point during the process of investigation, warrant seeking or warrantless access of material, should the principle of proportionality be levied?
Proportionality really is a process of considering the evidence and for using this method, for targeting this person, for using an alternative. So I think proportionality has sense only if you have criteria that somebody has to address and evidence they have to collect on each criteria, and then you do a weighing, a balancing exercise to see that they've come up with a proportionate result. In the void, I don't think proportionality, it's a vacuous concept unless you relate it to criteria and evidence.
Yeah.
And I know that there is there are unstated criteria, and there is evidence that's collected in this process, but it's not particularly transparent, and so that's really where the proportionality point comes in. The way proportionality operates is not really transparent or understood at the moment.
Well, we're trying to ground it. So, for example, Mr. Stewart, who presented evidence just before you on the Rule of Law from the Rule of Law Institute, I'm not sure if you were in the room, proposed a cut-off whereby you would need much more senior judicial official to hand out a warrant or to approve a warrant for a phone intercept, for example, whereas officials at different tiers of the hierarchy could apply for less invasive requests. Now, for me, that would be the principle of proportionality applied in one sense.
No, I don't support that proposal. I think it rests on an incorrect assumption that the judges bring a higher level of serious insight and knowledge and experience to this process than other officers, and I'm not satisfied as a general principle or from my own observations that that's the case.
Interesting.
My own, sort of episodic examination in this area is that the members of the Administrative Tribunal who do a high volume analysis do it very well and develop an expertise and an interest that's necessary. So I think oversight is important, but there are, we've moved in beyond the era of thinking that oversight meant judicial experience. There's a plethora of other options now that work quite well.
That's interesting. All right, last one from me. You, I think, mentioned, or you made some glancing reference to the PIM in whether we need public interest monitor or advocate.
Yes.
Inserted into the Commonwealth process. It operates, I understand, in Queensland, and I think one's just been set up in Victoria. Do you have any sense as to whether that inserting that kind of adversarial view to contest whether these things should be granted in the first place has improved due process in Queensland?
I'm not instinctively in favour of having a new body called a public interest monitor, and I have some concern that it can unduly formalise the process. In the mind of some, a public interest monitor should be a person with senior experience from the bar, and they bring, sometimes a quite formal adversarial or at least formally forensic view to it, and I don't think that's it's appropriate. I can see some instances where it may be a more suitable mechanism usually where there's a reluctance of executive agencies to accept oversight by commissioners, ombudsmen, inspectors, or sometimes an alternative process that may be used less commonly but has added safeguards, more reassurance because of its people involved or whatever. That may be more appropriate. But I would come at it by looking at what the gaps are and to the extent to which they can be filled by existing regulators before I'd commence designing some new kind of monitoring body. Did
the instance of the AFP raids on 7 West Media in Sydney a couple of weeks ago give you cause to doubt the integrity of the process, I guess, by which these warrants are sought and granted? Because that, to an outsider, looked like a disaster, that those warrants had been approved in the first place.
Yes.
That's the kind of instance, I guess, where you had somebody in the room who actually had read the documents and pushed back, might have prevented what looks to me to be a fairly substantial miscarriage of justice.
Yes, I haven't looked at that incident, Senator, so I have no comment to make.
Okay. We'll leave it there unless Senator Marshall
All right.
further questions. All right, thanks very much for your time this morning.